Defendants claim that Pound Cake fundamentally alters the message of the original work. That is, by editing the recording from "jazz is the only real music that's gonna last" to "only real music is gonna last," Drake transformed Jimmy Smith's dismissive comment into a statement on the relevance and staying power of real music, regardless of genre. And this is not one of those copyright disputes. This is a genuinely cool copyright dispute, and I think you're going to like this story. So for our next story, I wanted to talk about something that I learned this weekend. This was presented to me by none other than Joe Gratz of Dury Tangri, a law firm, an intellectual property law firm in San Francisco. He brought up a very interesting case this weekend and taught us all about Jimmy Smith. He played a sample for us. I don't have that sample, and I'm not sure that I have the same level of fair use that he was able to have for that. So I'll tell you about it, and you can go find it. I'm sure it's on Google Play Music and other services. Jimmy Smith is a musician who died February 8th, 2005. He popularized the jazz sound on the Hammond B3 organ. And so he's that guy. He's from Norristown, Pennsylvania, which is very close to me. It's about an hour south. He taught himself to play the piano. He won a Philadelphia Radio Talent Contest as a boogie-woogie pianist when he was 9. He went into the Navy, began exploring the Hammond organ in 1951. From there on out, that was the beginning of his career. And I don't have any music of his to play for you, so I found some music that sounds somewhat similar. And so I'm just going to put some music on in the background. And this would be something akin to Jimmy Smith, and I highly recommend that you go check out Jimmy Smith's music because he's really good. I mean, this is not one of those copyright disputes. This is a genuinely cool copyright dispute, and I think you're going to like this story. So we've got Jimmy Smith on one hand. He has passed, so this is his estate is going to be making this copyright claim against none other than Drake, who released a song using some of Jimmy Smith's words. Long story short is that Drake's use was found to be fair use. I'm telling you that now because I want you to keep that in mind as we go along here, that what you're hearing was found to be a fair use of Mr. Smith's material. And I'm going to leave the music playing. Let's go. Plaintiffs, the estate of James Oscar Smith, who will just be referred to as the estate, and Hebrew Hustle, who I think is that company I was referring to, who they go around and buy up rights, try to find infringements, vice versa. They go up around and find infringements and then try to buy up rights to support those infringements and then sue. They bring this copyright infringement action against defendants Cash Money Records, Universal Republic Records, UMG, Universal Music, EMI, MG, Universal Music MGB, Warner Chappell Music, Sony ATV, Aubrey Drake Graham, Matthew Yahoo Samuels, and Jordan Evans, Apple Inc., Amazon Digital Services. Plaintiffs and defendants both move for summary judgment. For the reasons that follow, plaintiff's motion is denied, defendant's motion is granted. Plaintiff's motion is denied, and defendant's motion is granted. In 1982, Jimmy Smith recorded an album released by Elektra Asylum Records entitled Off the Top. The first 6 tracks are purely instrumental, and the last track is a spoken word recording titled Jimmy Smith Rap, JSR. The lyrics to the JSR are, and I've heard this, so I'm going to try and replicate this a little bit. It's not a rap. He says, "Good God Almighty, like back in the old days, you know, years ago when they had the A&R men to tell you what to play, how to play it, and you know whether it's disco rock, but we just told Bruce that we want to play a straight jazz edge, so we got the fellas together, Grady Tate, Ron Carter, George Benson, Stanley Turrentine. Stanley was coming off a cool jazz festival, Ron was coming off a cool jazz festival, and we just went into the studio and we did it. We had the champagne in the studio, of course, you know, compliments of the company, and we just laid back and did it. Also, Greedy Tate's wife brought us down some home-cooked chicken, and we just laid back and we was chomping on chicken and having a ball. Jazz is the only real music that's gonna last. All that other bullshit is here today and gone tomorrow, but jazz was, is, and always will be. We may not do this sort of recording again. I may not get that these fellas again, George, Ron, Greedy Tate, Stanley Turrentine. So we hope you enjoy listening to this album half as much as we enjoyed playing it for you, because we had a ball. And that's the JSR statement that they're talking about for the rest of the thing, the Jimmy Smith rap statement. The label on each side of the record lists each song with the composer in parentheses, except for JSR, which lists no writer. Although Raymond Janifer, Jimmy Smith's nephew and co-manager of the estate, was not present at the recording of the JSR, he recalls Jimmy Smith telling him that he laid down a dynamite rap on them and hoped they don't cut it off the album. Jennifer also explained that Jimmy Smith did not write music, but instead made the music and words up in his head and then performed and recorded on tape. Additionally, the website Discogs lists Jimmy Smith as the author of the JSR. On September 24th, Cash Money Records and Universal Public Records released the album Nothing Was the Same by Aubrey Graham Drake. The last song in the album is Pound Cake Paris Morton Music No. 2, just called Pound Cake here. The opening to Pound Cake samples about 30 seconds of JSR. The sampled portions are Good God Almighty, like back in the old days. You know, years ago, they had the A&R men to tell you what to play, how to play it, and you know whether it's disco rock, but we just went in the studio and we did it. We had champagne in the studio, of course, you know, compliments of the company, and we just laid back and did it. So we hope you enjoyed listening to this album half as much as we enjoyed playing it for you, because we had a ball. Only real music is gonna last. All that other bullshit is here today and gone tomorrow. So that's a tiny bit different. Especially this part, only real music is going to last. Up here, he said, only jazz music is going to last. So that's different, and that's going to become a big part of this. In producing the album, Cash Money arranged for a music licensing company to ensure the parties obtained all the necessary licenses. Defendants obtained a license for the JSR recording, but not for the JSR composition. This is an important distinction. Music is usually an underlying musical composition as well as an overlaying audio track. So you've got the words, you've got the music, and those are two separate things, and when they come together, you've got a third thing. And when you put that to video, you've got a fourth thing. So there are already 4 copyrights in music, and there are actually more than that, so I'm not going to confuse you further. The JSR composition copyright was not registered with the Copyright Office or any performing rights organization prior to the album's release. The estate maintains that it would not have granted a license for the composition because Jimmy Smith wasn't a fan of hip-hop. That's also important, remember that. The estate maintains it would not have granted a license. The JSR recording license stated that defendants received all requisite consents and permissions of the copyright owners for the musical composition. Stephen Hacker is the principal of Hebrew Hustle, a music publisher that represents songwriters in negotiating the licensing of copyrights. Prior to the release of the album, Hacker had an ongoing business relationship with many of the defendants. Approximately 1 week before the album's release, Hacker reviewed an advance copy of the credits to look for openings in rights, sign those rights, and then disclose that to the Drake representatives after the release of the album. Hacker noticed that defendants had secured a license for the recording of the JSR, but not for the composition. He reached out to Jennifer to alert the estate of defendants' use of the JSR composition in the album. Thereafter, the estate entered into a co-publishing agreement with Hebrew Hustle, assigning 50% of the copyright in the JSR composition to Hebrew Hustle and granting an exclusive right to exploit it. Hebrew Hustle registered the JSR composition with the U.S. Copyright Office on October 23, 2013. 2 months after the album's release, the estate's counsel sent a cease and desist letter, which was the first time defendants learned of any alleged composition copyright interest in JSR. Now that's super interesting, because it says up here that he laid down the dynamite rap off the cuff. So where is an underlying composition? Where is an underlying writing to support that? I'm not sure that there is, but let's just assume for a moment that there is some kind of right there. It seems kind of like unclean hands already. Like they could have told them, hey, we also think that there's this copyright that you should secure, and they deliberately didn't. They deliberately waited until after so they could claim infringement. And that seems kind of shady already, right? This estate is not the most reasonable in my book. Let's put it that way. Summary judgment is appropriate where all submissions taken together show there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. Material facts are facts that might affect the outcome of a suit under the governing law. A dispute is genuine only if there is sufficient evidence favoring the non-moving party for a jury to return a verdict for that party. And this is your standard boilerplate summary judgment kind of paragraph, citing Celotex and Anderson versus Liberty Lobby and Anderson again. The basics of summary judgment are that you're asking the court to rule without a trial, so the judge can only take into account things that are undisputed. If the judge feels that there's no genuine dispute, and that genuine dispute has to be material facts, meaning important facts, and there's more to material facts, and the non-movement gets favorable evidence. So what does that mean? That means the opposing party, whoever the summary judgment is against. The dispute is genuine only if there is sufficient evidence favoring the non-moving party for a jury to return a verdict for that party. A dispute is genuine, and we need a dispute to undo or deny summary judgment. A dispute is genuine only if there is sufficient evidence that a jury could return a verdict for the other party, for the non-summary judgment party. So here we have cross motions for summary judgment, so both parties have filed motions for summary judgment. The role of a court in ruling on such a motion is not to resolve the disputed issues of facts, but to assess whether the thing can be resolved. Now, only admissible evidence need be considered. A party may not rely on mere speculation. Conclusions and standing alone are insufficient to create a triable issue. Here's the discussion of copyright infringement. To establish infringement, two elements must be proven: ownership of a copyright and copying of constituent elements that are original. Defendants argue that neither element is satisfied. Plaintiffs have no evidence that Jimmy Smith wrote JSR, and JSR and Pound Cake are not substantially similar. On the ownership of a copyright issue, the plaintiff bears the initial burden of coming forward with evidence that it possesses a valid copyright. Copyright in a work vests initially in the author or authors of the work. The author is the person who translates an original and minimally creative idea into fixed, tangible expression. And there's where the monkey selfie case comes in. The author must be a person. The estate derives its copyright from Jimmy Smith, who passed away February 2005. For the estate to hold the copyright, Jimmy Smith must have owned a copyright as the author of the work. However, the record evidence does not resolve the question of JSR's authorship. That's also a kind of a cryptic phrase. What do you mean, the record evidence? The record is the things that have been admitted into the court's docket, things that are submitted by the parties, rulings that the judge has made. They all affect the docket, and at the end of the day, you have a docket that represents the admissible evidence in a case and the procedure of the case. And the judge is allowed to use the admissible part of that here in resolving this summary judgment motions. As an initial matter, this court affords the January 2013 registration minimal weight. While copyright registration normally constitutes prima facie evidence of validity, automatic evidence, the evidentiary weight to be accorded the certificate of a registration more than 5 years after the publication shall be within the discretion of the court. Here, the estate registered the JSR composition copyright 31 years after initial publication, only in response to defendant's sampling of JSR on the album. Accordingly, the registration does not constitute prima facie evidence that the copyright is valid, and plaintiff has the burden of proving the validity of its copyright. The lyrics of JSR indicate that it is a behind-the-scenes recollection of recording off the top. Indeed, the statement on the Off the Top album cover explains that it was recorded with no charts, music, format, or nothing, just played what we felt off the top of our heads. But this information only speaks to the process of recording off the top and not necessarily to the authorship of JSR. Defendants claim the statement on the album is unauthenticated hearsay, but this statement is subject to the exception in Rule 803 of the Federal Rules of Evidence as a statement in a document that is at least 20 years old and whose authenticity is established. Interpreting this in the light most favorable to the non-moving party does create a dispute of material fact. Similarly, Jennifer asserted that Jimmy Smith did not write music by putting pen to paper, instead making the words up in his head before performing and recording the sounds on tape. But Jennifer did not witness Jimmy Smith record JSR, and that lack of first-hand knowledge makes his testimony less probative. A witness may testify to the matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Jennifer also claims that prior to the release of Off the Top, Jimmy Smith told him, "I laid down the dynamite rap on them and I hope they don't cut it from the album." Hearsay problems aside, there is no indication that Jimmy Smith was referring to JSR and not to some other song that was in fact cut from the album. The song listings for Off the Top are similarly unhelpful as they list the writers of each song except JSR. Because the lyrics were not displayed on the album jacket, they could not be visually perceived. Plaintiff's suggestion that there was no need to list the author of JSR because it was self-evident is circular, and therefore cannot support summary judgment. The fact that a single music-focused website recognizes Jimmy Smith as the author does not advance the inquiry. The website discogs.com or discogs.com, which plaintiffs claim is a commonly used and relied upon source, lists Jimmy Smith as the author of the JSR, but that website is a user-built database and anyone can contribute to it. There is no evidence that whoever entered the data had any personal knowledge of JSR's authorship. Ultimately, a genuine issue of material facts exists as to the authorship of JSR. Accordingly, summary judgment is not appropriate on this issue. Now remember, the court did grant summary judgment to defendant, so the court found it someplace. Substantial similarity. In order to establish a claim for copyright infringement, a plaintiff with a valid copyright must demonstrate that the defendant has actually copied plaintiff's work, and that the copying is illegal because a substantial similarity exists between the defendant's work and the protectable elements of plaintiff's. In general, the question of substantial similarity is a close question of fact. Therefore, summary judgment has traditionally been frowned upon in copyright litigation. Yet, summary judgment may be granted when any similarity concerns non-protectable elements or no reasonable trier of fact could find the works substantially similar. Multiple tests exist to determine substantial similarity, including the ordinary observer test, the comprehensive non-literal test, and the fragmented literal similarity test. Defendants argue for the application of the ordinary observer test, while plaintiffs maintain that the fragmented literal similarity test is appropriate. And there's a footnote 4 here. The comprehensive non-literal similarity test examines whether the fundamental essence or structure of one work is duplicated in another, and that's from Castle Rock Entertainment. Because this action involves direct copying, the comprehensive non-literal similarity test is inopposite. The ordinary observer test is the standard test for substantial similarity. It asks whether an ordinary observer, unless he set out to detect the disparities, would be disposed to overlook them and regard the aesthetic appeal the same. One more time, because this is super important, and they're being super clear here with very dense language. An ordinary observer, a regular, ordinary, reasonable observer, unless he was trying to find the disparities, if he's just going along normal, would be disposed to overlook the differences and regard the aesthetic appeal as the same. If you're walking along and you see things and you're not looking for things, you're not looking for it to be, you're not skeptical about it or whatever, you're like, is that Starbucks coupon the same as, a Starbucks logo and all that? And yes, the fake Starbucks coupon was really, really similar. It was absolutely the same. And so, would an ordinary observer, not trying to find the disparities, be disposed to overlook them and regard the aesthetic appeal as the same. I know I went over that like 4 times, but seriously, that's super freaking important. By contrast, the fragmented literal similarity exists where the defendant copies a portion of the plaintiff's work exactly or nearly exactly without appropriating the work's overall essence or structure. Under the fragmented literal similarity test, the question of substantial similarity is determined by an analysis of whether the copying goes to trivial or substantial elements. The question is whether the similarity relates to matters that constitute a substantial portion of plaintiff's work, not whether such material constitutes a substantial portion of defendant's work. Both tests ask whether the copying is quantitatively or qualitatively sufficient to support a finding of infringement. It is only where the points of dissimilarity exceed those that are similar, and those similar are, when compared to the original work, of small import, quantitatively or qualitatively, that a finding of no infringement is appropriate. One more time, it is only where points of dissimilarity exceed those that are similar, and those that are similar are of small importance. Then, when those dissimilarities exceed the similarities, and the similarities are of small importance, is it appropriate to say no copyright infringement. But because they involve literal copying in cases of fragmented literal similarity, more so than under the ordinary observer test, the copying of even a relatively small quantitative portion of the pre-existing work may be substantial if it is of great qualitative importance to the pre-existing work as a whole. For example, the hook of a musical composition is more important than one line of the verse, in generally speaking. So if you copy the hook of a song, that's going to be more likely to be a copyright infringement or substantial similarity than if you copied some other less important portion. Under either test, only the protectable portions of the copyrighted works are compared. To qualify for copyright protection, a work must be original to the author. Original means only that the work was independently created by the author and that it possesses some minimal degree of creativity. Where works have both protectable and unprotectable elements, the analysis must be done more discerningly, and the courts must attempt to extract the unprotectable elements from consideration, and asked whether the protectable elements standing alone are substantially similar. That means that we filter out the stuff that's not copyrighted. If I write a story, and the story involves dialogue on a park bench in a park with people in the park behind me, what's protectable and what's not? Guess what? I don't have a copyright on absolutely everything, absolutely, in that scenario. I have a copyright on the dialogue that I wrote, maybe the composition of the scene as it pertains specifically to my work. But other than that, dialogue in a park, not my copyright. I don't own that. That particular one nobody owns. But there are unprotectable elements in that. Similarly, if I use someone else's copyrighted work, let's say that I'm making commentary on a YouTube video like H3H3, and they're using segments of another's copyrighted work. The unprotected portion would be the part that they used of another's work that does not belong to them. So we're comparing the parts that are protected, that's their protected copyrighted work, with the parts that are not. So in this situation, the whole Jimmy Smith thing, he said those words, and the judge has to find out, okay, how much of that was used, how much of it belongs to Jimmy Smith, how much of it doesn't. For example, the written copyright doesn't exist on that from Jimmy Smith. He's not the one who wrote that down. He said the words, but he didn't write and create a copyright there. So the judge has to find these unprotectable elements, filter them out, and not use them in consideration. Cliché language is not subject to copyright protection. Made in America is not copyrightable as a title, as a lyric. It is far too brief, common, and original to create any exclusive right. Ordinary historical facts and events are not protectable. Only thin copyright protection exists for an original selection or arrangement of facts, but the copyright is limited to that particular selection or arrangement, such as in the Feist telephone book case, a telephone book. Although Pound Cake copies much of JSR verbatim, defendants contend that the sampled portion removes much of the factual account, is primarily cliché that is not entitled to protection, and only goes to trivial elements of the original work. Because the degree of similarity is high in such cases, the dispositive question is whether the copying goes to trivial or substantial elements. But courts do not dissect the works at issue into separate components and compare only the copyrightable elements. Instead, the court should compare the works for their total concept and feel. And while an ordinary phrase may enjoy no protection as such in its use as a sequence of expressive words, it does not cause the entire passage to lose protection. Thus, creative expression employing the use of cliched words may still be protectable. In the end, it would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of art outside the narrowest and most obvious limits. Ultimately, a determination of whether the copied portions of JSR are entitled to copyright protection depends on a subjective assessment better suited for a jury than a court. Accordingly, summary judgment on the elements of infringement is not appropriate here. Alternatively, defendants argue that plaintiffs' claims are barred by the fair use doctrine. Fair use is an affirmative defense to copyright infringement, see Campbell v. Acuff Rose Music, and thus the party asserting fair use bears the burden of proof. The doctrine of fair use has its roots in the ultimate goal of copyright law, that is, to expand public knowledge and understanding, a goal which copyright seeks to achieve by giving potential creators exclusive control over copying of their works, thus giving them a financial incentive to create informative, intellectually enriching works for public consumption. And that's from Authors Guild v. Google. Implied in this objective is the principle that while authors are undoubtedly important intended beneficiaries of copyright, the ultimate primary intended beneficiary is the public. Accordingly, courts developed the fair use doctrine to preclude a finding of infringement where the copyright law's goal of promoting the progress of science and useful arts would be better served by allowing the use than by preventing it. Once again, this is extremely important. The constitutional purpose and power of copyright law is to promote the progress of science and useful arts by allowing authors for certain limited times a monopoly on the copyright or distribution or patent, etc. So this is the underlying goal of copyright. If the copyright law's goal would be better served by allowing a use of a copyrighted work than by preventing it, then it should be deemed a fair use and allowed. Congress then codified the fair use doctrine in 1976. Notwithstanding the provisions of sections 106 and 106A, the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not infringement. And you're familiar with this. The first factor is the purpose and character of the use. The second factor is the nature of the copyrighted work. The third factor is the amount and substantiality of the portion used in relation to the copyrighted work of the whole, as a whole, and the effect of the use on the potential market, the market usurpation section or element. Because the fair use determination is an open-ended and context-sensitive inquiry, the examples and factors in the statute are illustrative and not limitive, and provide only general guidance about the sorts of copying that courts and Congress most commonly had found to be fair uses. That's in Cariou versus Prince, the 2013 Second Circuit case. Ultimately, fair use analysis asks a simple question: is this the type of use that furthers the essential goal of copyright law and should be excused from liability for infringement? Because copyright infringement involves highly fact-dependent analyses, courts should be especially wary of granting summary judgment. This is especially true in fair use cases, as the viability of the defense rests on the particular circumstances of each case and the balancing of various factual considerations. When the likelihood that additional non-cumulative evidence will be presented at trial is slight, however, summary judgment is appropriate. Although fair use is a mixed question of law and fact, courts in the Second Circuit have on a number of occasions resolved fair use on summary judgment. Okay, so they can use summary judgment, is what I was trying to say. Factor 1, purpose and character of the use. The first statutory factor, which courts have referred to as the heart of the fair use inquiry, focuses on the nature and purposes of the allegedly infringing use. The central question is whether and to what extent the new work is transformative. This is a critical issue because the more the appropriator is using the copyrighted material for new, transformative purposes, the more it serves copyright's goal of enriching public knowledge, and the less likely it is that the appropriation will serve as a substitute for the original or its plausible derivatives. Accordingly, the relevant inquiry on this factor is whether the new work merely supersedes the objects of the original creation, or instead adds something new with a further purpose or different character, altering the work with new expression, meaning, or message. Defendants advance 3 arguments for the transformative nature of their use of JSR. First, defendants claim that Pound Cake fundamentally alters the message of the original work. That is, by editing the recording from "jazz is the only real music that's gonna last" to "only real music is gonna last," Drake transformed Jimmy Smith's dismissive comment into a statement on the relevance and staying power of real music regardless of genre. Second, defendants note that Pound Cake omits all references to the recording of Off the Top, thereby making the words applicable to the process of making Drake's album rather than Jimmy Smith's. Finally, defendants claim that the addition of background music, the rearrangement of some words, and the placement of the recordings in a 7-minute hip-hop track renders their use transformative. Defendants' second and third arguments are misplaced because they conflate the nature of the fair use with that of a derivative work. The word transform appears in the statutory definition of derivative works, which of course requires a license and are not protected by the fair use doctrine. Although derivative works typically involve transformative changes, the statutory definition suggests that derivative works generally involve transformations in the nature of changes to form. Thus, when a new work transforms a copyrighted work but uses it for the same purpose for which the original is sold, the new work is a derivative work rather than a fair use. Drake's use of JSR to describe his own recording process, although literally transformative in the sense that he does not appropriate JSR verbatim, would bear the same purpose that Jimmy Smith had for it when he first recorded JSR. Accordingly, these arguments cannot support a fair use defense. Defendant's first argument, on the other hand, strikes a compelling reason to find this use transformative. There can be no reasonable dispute that the key phrase of JSR, "jazz is the only real music that's gonna last, all that other bullshit is here today and gone tomorrow, but jazz was, is, and always will be," is an unequivocal statement on the primacy of jazz over all other forms of popular music. Defendant's use of JSR, by contrast, transforms Jimmy Smith's brazen dismissal of all non-jazz music into a statement that real music, with no other qualifiers, is the only thing that's gonna last. Thus, defendant's purposes in using the original work are sharply different than the original artist's goals in creating it. This is precisely the type of use that adds something new, with a further purpose or different character, altering the first work with new expression, meaning, or message. Plaintiffs contend that this use cannot be transformative because the copied portions are not readily identifiable as JSR. Thus, plaintiffs argue that there can be no viable claim that Pound Cake is commenting on an obscure spoken word track by a relatively unknown jazz musician. This argument fails because plaintiffs seek to apply the standard for fair use in parody to this non-parodic use. Although it is certainly true that the object of a parody must be ascertainable to the average observer, and with reason, for what good is a parody if the listener cannot identify the target of derision, this is not a universal prerequisite for finding a transformative use. In Blanche v. Coons, the the court found that the defendant's appropriation of a small part of a magazine advertisement into a larger mixed media artwork was a transformative use, even though no reasonable observer could identify the legs as being used from the original advertisement. Because the defendant used the copyrighted work as raw material in furtherance of a distinct creative or communicative objective, the Blanche Court found the use was a transformative use. Similarly, defendant's use of JSR is transformative regardless of whether the average listener would identify the source of the sample and immediately comprehend Drake's purposes. The critical question of how the work in question appears to the reasonable observer is not the quality or accessibility of the commentary from Carew. The average listener of Pound Cake would understand the sampled portions of JSR as a statement that, regardless of how a song was made or how one might classify it, only real music is going to last. Because this purpose is sharply different from Jimmy Smith's purpose in creating the original track, defendant's use is transformative, and this factor weighs in favor of finding a fair use. The second statutory factor, nature of the copyrighted work, calls for recognition that some works are closer to the core of intended copyright protection than others, with the consequence that a fair use is more difficult to establish when the former works are copied. Two types of distinctions are made: whether the work is expressive or creative, or whether the work is published or unpublished. As the Second Circuit has noted, this factor is rarely found to be determinative. Because JSR is a work of creative expression, this factor weighs against a finding of fair use. Factor 3, the amount and substantiality of the portion used. The clear implication of this inquiry is that a finding of fair use is more likely when small amounts are copied than when the copying is more excessive. Plaintiffs contend that defendants appropriated an unreasonable portion when they used 35 seconds of a 1-minute track. The law does not require, however, that a secondary artist take no more than necessary, and instead permits the secondary user to conjure up at least enough of the original to accomplish the purpose. Here, the court found the amount taken to be reasonable in proportion to the needs of the intended transformative use. Accordingly, this factor favors a finding of fair use. The final factor, the effect on the market for the copyrighted work, analyzes the effect of the secondary use upon the potential market for or value of the copyrighted work. As the ability to reap financial rewards from creative endeavors is a critical component to the copyright regime, the Supreme Court has noted that this factor is undoubtedly the single most important element of fair use. At this stage, courts ask whether the copy brings to the marketplace a competing substitute for the original, or its derivative, so as to deprive the rights holder of significant revenues because of the likelihood that potential purchasers might opt to acquire a copy in preference to the original. Noting that the concern is not whether the secondary use suppresses or even destroys the market, but whether the secondary use usurps the market for the work, is Carew and Authors Guild. The fourth factor is also, however, closely linked to the first, in the sense that the more the copying is done to achieve a purpose that differs from the purpose of the original, the less likely it is that the copy will serve as a satisfactory substitute for the original. There is no evidence in the record to suggest that Pound Cake usurps any potential market for JSR or its derivatives. JSR, a spoken word criticism of non-jazz music at the end of an improvisational jazz album, targets a sharply different primary market than Pound Cake, a hip-hop track. Further, Plaintiff never attempted to establish a market for licensed derivative uses of the JSR composition until after defendants used the recording on the album. Thus, the fourth factor favors the defendants. Having considered the four factors in light of the goals of copyright law, the court concludes that defendants' inclusion of the copied portion of the JSR is a fair use and does not infringe plaintiff's composition copyright. And then the judge goes on to find, as we said before, the plaintiff's motion for summary judgment is denied and the defendant's motion for summary judgment is granted. And so that is that. That is the estate of James Smith versus Cash Money Records, which is Aubrey Drake Graham. And that's the important takeaway from that, is that he used only the portion that he needed. He used it for a transformative purpose. The original text was saying that jazz is the only real music that's going to last. And because he transformed that purpose by saying only real music is going to last, that was a transformative use enough to become a fair use. and therefore Drake is not committing copyright infringement whatsoever. You can see why a lawyer includes multiple arguments in his or her drafting and filing of a complaint or a response or whatever, because you never know what one argument might be the one the judge goes, okay, yeah, that's the one right there. Sometimes you have to understand, sometimes like you're still feeling it out as you're writing these things. Like these things are happening that quickly and they're that new. So it's sometimes you're making new arguments that haven't been made before. And in this case, in all copyright fair use cases, they are to a point arguments that haven't been made before because they're all new copyrighted works. So he used this sampled portion, which is normally a sample, right? Like you made a per se copyright. It's copyright infringement, but it's per se copyright infringement that is a fair use because he transformed the purpose of it. And this is why I think you see fewer lawsuits over sampling, because a lot of times, even though something has been sampled, it is still being used for a transformative purpose and in a way that does not usurp the market for the original. So that's it. That's a very interesting case, and even I learned a lot about substantial similarity and that fragmented test or whatever. I didn't know there was a fragmented test. I knew there was a substantial similarity test, but I didn't know that there were actually 3 in the Second Circuit. So what do we think of that? Thank you all for joining me today. Thank you especially to our Patreon supporters. Currently, Kareem Harper is supporting at the $500 plus level for a video on the Cambridge Analytica data privacy Facebook thing. And we're working on that, and that should be sometime this week. I keep saying 2 weeks. I don't want to say 2 weeks anymore. That should be sometime this week. We do want to get through DJ Gilcrease's Lexmark case first. He asked for that before, and I don't want to make him wait for that even any longer. We have finished a full script on the DJ Gilcrease piece and the Lexmark case, and I just have to now edit that script down to something that's less than an hour and a half long. So thank you also then to our $50 plus supporters, DJ Gilcrease, John Steele, Gavin Barnard, The Godslain, Evie, Andy, Kyle Mudrock, John H. Anderson, Veramint Tain, Sean McNamara, William Gonzalez, Michael Pierce, and LVE. The $5 plus supporters are scrolling on the screen and on the LED panel behind me, and thank you so much to the 210 of you that are contributing $5 plus a month. Of course, I am Leonard French, your favorite copyright attorney, and this is the channel where we educate the lawful masses. We really appreciate you joining us today. I love you all. Have a great week. I'll go open up a door and see if I can find a dog, and you guys can trail off as you want. People want to see you still. People, he just slid. Did you just slide? I'm sorry. He tried to jump up and he slid. So, you can go up. Go girl. Go girl. Go girl. You're so wonderful. Are you looking for treats? How's your leg doing? Go girl. Alright, fine. You want one more, Nico? Come here. Up. Oh, I got the other one. Go girl. Alright, guys. Have a good afternoon, good evening, good week. I'll see you in the videos. Love you all. And, bye. This is in the United States District Court for the Southern District of New York. Woo! York. That's the best one. We're keeping that one. York. In my face. Well, I'm glad we're recording this. Wow. I need a moment. Are you sure that's root beer? Yeah. Yes, absolutely root beer. I do not think the stream would be any better if I was intoxicated. So this is in the United States District Court for the Southern District of I almost did it again. You hear it? I almost did it again.